Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and it looks like things are starting to heat up, okay? Not only in the Eastern District of New York, but also in the Northern District of New York. And so I am bringing you guys my water theme once again, because I think we all need to be relaxing our mind, not being so hostile and aggressive and carrying on towards one another. So the story behind this water scene, before I get into this content, is that I had went out to the park. You know, guys, I've shown you that park that I walk to in the morning time. And so I usually go out on the gazebo that goes out over the water. And so on this particular day, there was a guy and he was teaching a kickboxing class. And so I was like, okay, how you just gonna take over the gazebo with this kickboxing class, right? So then it was just like, there used to be this, and I think I mentioned this to you guys before too, about the group of people from the Alcoholic and Narcotics Anonymous group that for years have met at this park under the largest shelter that's out there, picnic shelter that's out there. And so on the day that this guy was there with the kickboxing, they weren't under the shelter like they normally are, but it was like some other people under the shelter. So it was just one of them days where it was a lot going on. It was just hectic, right? So then I said, okay, well, let me walk down here to the other end of the park, you know, and I'll do my video from there. And so every place was taken in the park except for this one bench that sits, and I think they just haven't cut those bushes back in a while, so you can't really, it's hard to see the water. But there was like there was a bird walking through, and so I was like filming the bird. And then I said, oh, let me just go ahead and do my content. And so I've actually muted out the content on the original video. And then the video that I did, you guys, yesterday, I was just using the scenery. And so I'm going to use that scenery again today for this video, because I don't feel like setting up my lighting and all of that stuff that goes along with doing the videos in person. And so what we're going to talk about today is a back and forth between Steve Greenberg and Angel Cruel. And you guys know Angel Cruel is the Assistant United States Attorney over the Northern District of Illinois case against Robert Sylvester Kelly. And so Greenberg wrote to Angel Cruel on July 21st, and he says, Dear Miss Cruel, I am following up on our telephone conversation from last week regarding the latest Discovery production. As I am sure you can understand, I, as well as all of Mr. Kelly's other counsel, we are alarmed that included within the latest production are bank records belonging to several of Mr. Kelly's counsel. Your obtaining of these records is out of bounds. It is offensive, it is unprofessional, and it should not have occurred. Initially, we see no reason for the government to have subpoenaed this information. The state reason, at least for Mr. Blank, and they have it blocked out records, was because monies had been received by him from the, quote, some brother love, end quote, bank account. This is a child farcical, I think farcical, FARCICAL reason. Under that logic, at best, the information was sought because he received a single transfer on May 2019 of $2,500. We fail to see how that single small payment for legal fees justifies your seeking his professional records, including his client trust records, which under New York law are privileged, going back 6 years. Moreover, even if there had been some justification for your seeking these records, it is obvious there was nothing in them that showed any sort of wrongdoing. Accordingly, we failed to understand why they were then produced to all of the attorneys in the case, other than to cause embarrassment and to intimidate counsel. Just as you have no right to this information, nor do other attorneys representing the other defendants. And our concerns are not limited to Mr. and then the name is blanked out. We likewise fail to understand why information was obtained from other counsel who represent Mr. Kelly. It too represents an unwarranted intrusion into their attorney-client relationship, as well as counsel's business affairs. There is no reason for this kind of intrusion into the private business affairs of attorneys. Of course, all of these raised, Lord, here he go again. Of course, and I'm just going to use the correct English here. Of course, all of this raises fear as to where the intrusions will stop. Are you going to seek my personal and private records, those of Mr. Leonard or Mr. Groman? As with the others, there is no reason to do so, but the fact, and that should be that you, not you that. The fact that you have already exceeded the bounds of what is acceptable concerns each of us. We are demanding that you A, provide us with written assurances that you are going to cease prying into the relationship between Mr. Kelly and his counsel. B, cease your investigation of his counsel. C, provide us with copies of any subpoenas that were already issued for records. D, require other counsel to return the disc with these records and that they be issued a new disc without the records. And E, that you advise us whether these records were shared with any other prosecutors or law enforcement. We expect answers to these questions and your assurances no later than Tuesday, July 21st, or we will seek intervention from the court. Sincerely, Stephen Greenberg. Now, he demands a response by Tuesday, July 21st, but this letter was written on July 21st, so I don't know how he expect a response back that fast. Then, let me say that I believe that the Mr. who is blanked out is probably Doug Anton, and because he says that he joined in May, and that was around the time when Doug Anton showed up, I believe. And he doesn't say when they issued the subpoena, but I'm thinking, so it says, under the logic at best, the information was sought because he received a single transfer in May 2019 of $2,500. So I am going to say that this probably is Doug Anton, because remember, Doug Anton came on after the fact when all that hoopla was going on about the concerts in Dubai. And then depending on when they subpoenaed this information, I'm wondering if it is in regards to the infamous defense fund that was started. So that'll be interesting to see. We'll probably never know why they subpoenaed the information. But anyway, that was Steve Greenberg's letter to the Northern District of Illinois. So Angel Crew responded back the following day on July 22nd. And this was her response. It says, Dear Mr. Greenberg, per your request in your letter dated July 20th, 2020, okay, his letter was dated July 21st, unless there was another letter or his letter was misdated and faxed over on the 20th. It says, we will ask counsel from Daryl McDavid and Milton Brown to return disc 49 to be replaced with a disc that does not contain the attorney bank records. We will notify you when that is complete. As I stated in our phone conversation, the government subpoenaed various bank accounts for receipts of funds from the Some Brother Love bank account to show that Mr. Kelly and not Mr. Calbert controlled the funds in that account, and that the assignment of certain royalties from Mr. Kelly to Mr. Calbert was not an arm's length transaction, and that Mr. Kelly retained control of those funds despite the assignment of royalties. Regarding your remaining requests, we are unaware of any statute, rule, or case law that requires a response. If you disagree, please provide us with such authority. Yours truly, John Louch, United States Attorney, but it was actually written by Angel M. Cruel. Okay, so they basically telling Steve Greenberg that they can get whatever records they want to get, okay? And that they are able to justify why they subpoenaed those records, and then let this be a lesson to all of us that the government be spying on our bank accounts and how we are spending our money. So Steve Green filed a motion, and I'm not sure if he filed this motion after their response, or I'm thinking he must have filed it after their response. I don't see a date on here, but let's go ahead and read this. So it says, motion to require the disclosure of grand jury subpoenas, production of all grand jury materials, and for a protective order. And you guys, like I said, remember I told you that the closer we get to the court hearings the trial supposedly starting, expect to see more and more motions being filed in the case. So it says, defendant Robert S. Kelly, by and through his undersigned counsel, respectfully moves this honorable court for the entry of an order requiring the government to immediately disclose all requests for records and grand jury subpoenas that have been issued in this case, to produce all documents produced in response to those requests, and for a protective order barring the government from further prying into the irrelevant records of Mr. Kelly's counsel. In support of this motion, Mr. Kelly states as follows. 1. On July 17, 2020, the government disclosed new materials to defense counsel in this case. Within that disclosure were voluminous bank records. None of these bank records had been redacted. The bank records were from entities associated with Mr. Kelly, including RSK Entertainment Worldwide Incorporated, RSK Enterprises LLC, and Some Brother Love LLC. The records also included personal banking records for the 3 defendants in this case, Mr. Kelly, Mr. McDavid, Mr. Brown, as well as others associated at least at some level with Mr. Kelly. 3. Incredibly, among the bank records produced were records from one of the individual attorneys currently representing Mr. Kelly in his federal criminal case in New York, and from a major international law firm who had previously represented Mr. Kelly. The attorney's records date back to 2013, the law firm's even further. 4. There are records from several of the individual attorney's accounts, including his checking and client trust accounts, as well as his debit and credit cards. 5. The records from the international law firm are all encompassing. They include checking and wire transfer records. 6. The records the government obtained were not limited to transactions with Mr. Kelly or any of the other defendants. The records reflect thousands of banking transactions. They are a roadmap of financial transactions involving his attorney and for the international law firm. 7. The government does not have and never had any lawful basis to believe that either the New York lawyer or the law firm ever engaged in any type of improper conduct. In short, the government went on an unreasonable, intimidating, and harassing fishing expedition into the records of Mr. Kelly's current counsel, as well as into the records of one of the country's preeminent law firms. 8. Neither the individual New York defense attorney or the international law firm was provided with a copy of any request for records or subpoenas before the records were produced, or any opportunity to object. Indeed, to date, neither has seen any of these documents. 9. Appropriately alarmed by this clear overreach, Mr. Kelly's Chicago Defense Counsel reached out to the government and sought the reason for this unprecedented intrusion. The explanation provided was that the records were necessary to show that Mr. Kelly was diverting monies to the Some Brother Love LLC account, specifically his royalties, and that the monies from the account were being used to pay Mr. Kelly's expenses. That explanation makes absolutely no sense. Individuals form entities to manage their affairs, including paying their bills all the time. 10. The Some Brother Love LLC bank records reflect an extremely small payment in May 2019 to Mr. Kelly's New York Defense Counsel. That payment was for representation in a civil case. In May 2019, there was not yet a criminal case. I'm still thinking this is Anton, because I know Anton currently is handling the Faith Rogers civil suit. And I'm trying to think, who was the attorney? There was an attorney prior to Anton, maybe. Because when was that case? That case was supposed to go to court. I can't remember, guys, but I do know that Anton is on that case now, and there may have been another attorney prior to him, or there was another attorney prior to him. And when I'm loading this, I will go and look, because I actually talked about that attorney in a video that I did about the Faith Rogers case. So number 11, Some Brother Love LLC is a company that was formed to accept royalties and pay expenses for Mr. Kelly. It was at all times been properly registered, and its taxes have been paid. It was formed after Mr. Kelly was incarcerated in this case, although its bank account was opened shortly beforehand. 12. There was nothing odd or unusual about the extraordinarily modest payment to Mr. Kelly's New York counsel. He was hired and paid a very small retainer. The fact a lawyer is hired and paid does not give the government carte blanche to request banking records. 13. It appears neither request was narrowly tailored or limited to a relevant time period or to Mr. Kelly or his entities. The government has all of the bank records for years before the New York Counsel ever began representing Mr. Kelly, and a decade of the international law firms. 14. More to the point, the government already had evidence of the payment from Some Brother Love LLC to the New York attorney when they obtained the Some Brother Love LLC banking records. And if they wanted to confirm the recipient, the subpoena should have been narrowly drafted. They did not need 6 years of the attorney's substantive records or those from an international law firm. 15. Mr. Kelly's counsel well understands that a grand jury has broad powers to investigate. However, those powers are not absolute. See United States versus R Enterprises Incorporated, which is a 1991 case, and they're citing from that case, the investigatory powers of the grand jury are nevertheless not unlimited. Grand juries are not licensed to engage in arbitrary fishing expeditions, nor may they select targets of investigation out of malice or an intent to harass. And then they talk about Serig versus Hines, which was a 1981 case, recognizing that grand jury subpoenas can be, quote, challenged by an affirmative showing of impropriety, end quote, including bad faith, end quote. Then it says Trump versus Vance. Grand juries are subject to judicial supervision, and a subpoena may be quashed or modified if compliance would be unreasonable or oppressive. Then they go on Brandsburg versus Hayes regarding grand jury matters. Although service of a grand jury subpoena on an attorney representing the target of the investigation and pending related criminal proceedings is not unprecedented. Then another case, it is highly unusual insofar as we can tell from the case law and implicates serious policy concerns. The district court could weigh those policies and conclude that the potential disruption of the attorney's relationships with their clients at the crucial period in their preparation of their client's defense made the subpoenas unreasonable and oppressive at the time they were served. So then he goes on to point 16, to obtain the banking records of Mr. Kelly's New York defense counsel because he was paid an insignificant retainer is a prime example of a charter boat fishing trip. To obtain that attorney's financial records going back 6 years before he ever first came in contact with Mr. Kelly is not only outrageous and an abuse of the grand jury process, it was clearly not a way to establish anything that could conceivably have any relevance to this or any other criminal prosecution. 17. The explanation offered so far by the government that it was merely following the money trail is entirely without virtue for many reasons, including the following. A. Mr. Kelly has every right to have his royalties go into whatever bank account he wants. B. In order for the royalties to be deposited into an account, Mr. Kelly had to provide documentation to the paying entity stating that he wanted his royalties to go into that account, i.e., it had to be an above board and transparent transaction. C. There is absolutely no issue that this information could possibly be relevant to. And D. Even if the government felt some need to show that this account was a subterfuge, that does not require years of records from multiple law firms. 18. There is another concern, the lack of notice of counsel. Although the records were obtained at the beginning of the year, no notice was ever provided to the New York attorney or the major international law firm that records were being sought. Such notice should have been provided. See U.S. Attorney's Manual, section. Where did it go? Let me go back. Okay, what happened here? Okay, Manual section 913.410, subpoenaing attorney records related to client representation. Number 19, obviously what the government has already improperly done here cannot be unwound. Still, after reviewing the materials and speaking with the government, defense counsel sent a letter that requested the government A. provide written assurance that it would cease prying into the relationship between Mr. Kelly and his defense counsel. B. cease its investigations of his New York counsel. C. provide Mr. Kelly's defense counsel, in this case, with copies of any subpoenas that have already been issued for records. And D. require the attorneys for the other defendants in the present case to return the disc containing the offending records and advise them that they will be issued a new disc without the records. And E. that the government advise Mr. Kelly's defense counsel whether records at issue were ever shared with any other prosecutors or members of law enforcement. A redacted copy of the letter to the government is attached hereto as Exhibit A. 20. In response, the government replied that it would request counsel for the other defendants to return the particular disc to issue so that NYDC records may be removed. However, with regard to Mr. Kelly's counsel's other requests, the government advised that it is unaware of any statute, rule, or case law that required a response. A copy of the government's letter is attached and is hereto as Exhibit B. 21. Accordingly and justifiably, Mr. Kelly requests this court rein in the government. Mr. Kelly is requesting a copy of any and all requests and or the grand jury subpoenas for the requests at issue and any other bank subpoenas. He immediately be immediately produced, regardless of whether the records have already been obtained by the government, so that an evaluation can be made whether a motion to quash would or will have been appropriate, and if so, a motion can be brought nunc pro tunc if necessary. Okay, we gotta look that up, see what that means. The United States versus Kitsabar, holding that because the government did not in any manner tailor its request to relevant material, the subpoena was unreasonably broad and within the district court's supervisory power and responsibility to quash. In regard, Grand Jury 194, then they talk about a case D Mass 2000, be permitted to serve grand jury subpoena on civil attorney of client indicted by grand jury, given real and immediate risk of chilling client's Sixth Amendment rights. Further examination of these records may be necessary to see if the government violated the attorney-client privilege, necessitating that existing prosecutors recuse themselves. 22. Beyond that, the defense seeks an order from the court restricting the government's obvious effort to intimidate and harass Mr. Kelly's defense counsel. The fact that Mr. Kelly has paid defense counsel should not make their financial records or even their financial dealings with him fair game for a criminal subpoena. The fact that counsel is paid to represent a client does not make counsel's banking records fair game. 23. Go back up here. Moreover, so that there is full transparency and as a sanction for what is really outrageous conduct by the government, this court should order that the government be required to immediately produce to Mr. Kelly's defense counsel each and every grand jury subpoena that has been issued to date, as well as every document obtained under the guise of each such subpoena. 24. In sum, it will take such an order from this court to fully bring to light the full nature and extent of the government's transgression, and such an order will hopefully go a long way in making the United States Attorney's Office think twice before engaging in any such similar conduct in the future. Respectfully submitted, Steve Greenberg, one of defendant's attorneys. And then it lists Greenberg, Mike Leonard, and Christopher Groman, and they're all in Chicago. And so we know that Doug Anton, who has been extremely quiet, hasn't really been listed on anything, not even sure if he's still on the case or not, is probably the person that they're talking about. And then I said I was going to look up this nunc pro tunc, whatever that is. Nunc. Okay, pro tunc. See what that means. Okay, English translation for now, for then, is a Latin expression in common legal use in the United States, the United Kingdom, and other countries. In general, a ruling nunc pro tunc applies retroactively to correct an earlier ruling. Okay, so guys, what do you think about the Northern District of Illinois using a grand jury to subpoena all of these records, these financial records going back to 2013 for Mr. Kelly's legal firm and for whoever this attorney is in the New York civil case, which we know Doug Anton at some point was handling the civil case. And I believe he took that case over from somebody else. And like I said, while this is loading, I'm going to go ahead and research to see who was handling this case first. Because if you guys remember, I did a video on the Lydia lady who was Faith Rogers' attorney. They were supposed to be heard before a judge last year sometime, but the attorney had been arrested and was on trial for some illegal money dealings and a real estate deal with her aunt, who had been told that she had to surrender this property to pay these government fines or whatever. And on the same day that hearing was supposed to take place, R. Kelly was actually in court himself, or getting ready to be arraigned on, I can't remember if it was the state case, or I believe it was the state case, because all of this happened, I believe, before the federal charges were filed. And so everybody was like, oh, he was going to get a judgment. He's going to get an automatic judgment against him because he can't appear at this hearing. And then that's when the news broke that Faith Rogers' attorney was facing legal trouble herself, and then she had to withdraw, and then the case was delayed for months, and I think it was around September, October before the case was picked back up. And then at that time, Doug Anton had signed on to the case. But I'll go back and look at those records and to see if there was another attorney representing R. Kelly at the time that they may be referencing here. But I believe that if they subpoenaed those records on Doug Anton, that it probably has something to do with that defense fund, and they're trying to figure out, because why else would they also get the records for his client trust accounts? And so this is the danger, in these people with these defense funds and trying to use these attorneys, is that, it really falls back on the attorney if the attorney gets involved in all these other shenanigans that's going on. So I am going to wrap this up. If you guys didn't see the video that I posted last night, it was actually talking about, oh my God. It was a motion that was filed. What was that motion for? I'm losing it, guys. I'm losing it. Let me see what that motion was for. It was the response. I remember Mike Leonard had requested extra time to respond to the anonymous jury, and he said that he would try to file a response by the 29th. Well, he did do that yesterday. And so you guys need to go check that video out. I didn't give it a name, including R. Kelly's name, because I'm trying to experiment because, to see if I can get them to stop demonetizing my videos when I talk about about his case. And so I'm just experimenting with some different things. And anyway, check that video out. I'll also put the link in this video. There was a little interesting tad bit in that in the motion that he filed that I think you guys would find quite entertaining. So that's it for me. I'm gonna leave you guys with this. Leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.